3, it's supplementary corporation. So maybe have other words. Neither will refer to the division and similar substitute matter already.
Serial number 3.
Yes,
No, it's a covered matter. Very important.
Serial number.
You are for the respondent.
no.
It's a covered matter. You were absent from the last year.
From the list members. Serial number 23. It is
Serial
bail
number?
matter. 23 members.
Yes.
From the list. It is regular bail matter.
Call the other side. Other side to बुला के.
Also, the serial number 3 lawsuit was
Will be
said.
taken up at 11:30.
Serial number 3 lawsuit has said that this is a covered matter. It is
It is
a
a covered
referred matter. Lawsuit has already referred 2 cases to the division bench. So same order can, if lawsuit see the same.
ऐसा क्या करते? इतना भी क्या हड़बड़ी है कि आप कॉल आउट होने तक वेट नहीं कर सकते? Let me just understand. You wait. Why do you need to mention it? जब कॉल आउट होगा तब एब्सेंट रहते हैं.
हाँ, उस दिन मेरी
हाँ. इसीलिए गलती है तो रुकिए वेट करिए.
Supplementary is for order 25 item 2, Contempt Civil 48 of 2023.
Contempt Civil 48 of 2023. Nobody appears on behalf of the petitioner. 170, 125 also nobody had appeared on behalf of the petitioner. Accordingly, time till next Friday is granted to the petitioner to remove the surviving defects ready. If the defects are removed within time, post this case on 14th. Also for the state is present.
Petition item 4, Contempt Civil 856 of 2023.
Yes.
On the previous occasion, it was submitted by the college, the university that an amount of ₹29,80,591 has been remitted to the college to be disbursed to the petitioners. Petitioner he has not got a single penny there.
In June, he has received.
Receive the amount.
We had taken instructions on phone. He said that he has not received.
Where is he?
We'll call him.
No, ask him to join online. Wherever he is. Wherever he is, ask him to join online.
Leadership, if these documents may be filed, at least we would have been known because it was not intimated to us by the.
You file an affidavit that you have not received.
Yes, that is the best. If he has not received, let him file it. Yes.
And you have received instructions. Take the instructions on message. Please take it on message.
Yes.
Before you make a statement like this,
Yes. Yes.
you should take it on message.
Yes. And he'll have to come any which ways to file the affidavit. He has to sign that affidavit. That is better.
The learned counsel for the parties are present. The learned counsel for the opposite party has submitted that the petitioner has received the amount. However, counsel for the petitioner has submitted that he has received instructions that the petitioner has not received them. Counsel for the opposite party is directed to bring the documents regarding proof of receipt of the amount by the petitioner by filing an affidavit, and the petitioner is also directed to file the required affidavit. Where is he located?
Gumla.
The required affidavit be filed by 11th of February. Post this case on 14th. आप उसको affidavit में लिखें.
This is shocking for me as well. If he has received, he should have disclosed it.
The college has transferred the amount. It is back. And he says that he has not.
Item 5, Contempt Civil 916 of 2023.
Lordship, I'm praying that this matter will be taken up on next Friday, Lordship. The show cause is ready, but it could not be sworn, Lordship, by the officer. The officer is coming today, Lordship. So I'm praying next week, any day, it will be taken up, Lordship.
Contempt case civil number 916 of 23. Counsel for the parties are present. Counsel for the opposite party submits that the show cause is ready and the concerned officer is coming today for swearing the affidavit. Let the show cause be filed by Monday. Post this case in Tuesday. On Tuesday, the supplementary business.
May post on Wednesday, Lordship, because
आपके चॉइस से क्या है?
48 hours before we have to
कोई
file.
बात नहीं, यहाँ से परमिशन मिल जाएगा.
Item 7, Contempt Civil 1113 of 2024.
For finding someone.
Show cause और compliance report दोनों में फर्क है ना? Contempt case civil number 1113 of 2024. Nobody appears for the petition. Counsel for the opposite party prays for and is granted 1 week time to file compliance report. 1 week में हो जाएगा?
2 weeks.
2 weeks time to file compliance report. Let the compliance report be filed by 14th of February. Post this case on 18th of February in the compliance process. आप इसको follow up करिए, ठीक है? Anybody who sits over an order is also liable for penalty.
Item 8, Contempt Civil 1159 of 2024.
Order is not in compliance yet, my lord. Despite the order passed by.
Lordship, we have received the instruction, but due to some constraints, we couldn't file the show cause. But we have written to the Accountant General Bihar and Ranchi to avail the family pension.
Matter relates to family pension, my lord, of the deceased wife. Since 1996, they are not able to file the family, issue the family pension.
96.
96 died, my lord.
That's right. When did you file the requisition?
My lord, because
2023.
of the reason, my lord.
Whatever be the reason, so don't blame them for everything.
Yes, I am not blaming on you.
You share some blame on yourself also.
My lord, I take the responsibility also. But since
You
matter
have,
is there,
who is there for AG office? Who is there for AG office?
Accountant General Bihar is also necessary party, my lord. I have also added the party. Mr. Sumit Kumar Agarwal is appearing. Last day also he was not appearing. SK Agarwal name is appearing in the list from Accountant General Bihar. Since the petitioner was working in last while Bihar, my lord, therefore Accountant General Bihar is also necessary.
You have made Accountant General Bihar
Yes,
and Accountant General
Jharkhand is not. Since the necessary action has to be taken from the Accountant General Bihar, because the petitioner husband of the
who represents Accountant General Bihar?
Mr. Sunil Kumar Agarwal, on the last occasion also
Where
he
is
did not
he?
appear. His name is appearing.
Last time क्या? Yes?
बोले कि अभी आ रहे हैं रात में
तो जब तक वो नहीं आते 10:30 नहीं बजता है क्या हाई कोर्ट में? उनके आने के बाद ही 10:30 बजता है, ऐसा है कोई नियम? बुला के रहिए, he's on the way.
Item 9, Contempt Civil 168 of 2025.
Yes,
My lordship, order was not.
about
Police party. My lordship, page 20, my lordship, next for my lordship. This is the order.
page number?
Page number 20, my lordship. Compliant with this order, my lordship.
Quickly. Contempt case civil number 168 of 2025. This petition has been filed alleging non-compliance of order dated 3/4/2024 passed in WBS number 613 of 2023. Also for the petitioner has submitted that. in spite of filing the required representation, no order has been passed. Counsel for the opposite party state has submitted that notice may be issued to the opposite party. Considering the submissions, let notice be issued to opposite party number 2 to the concerned police station, for which recusal be filed by the petitioner by Monday.
1 week में
आपको कोई गड़बड़ी नहीं है? By
1
Monday,
week 1 week होगा
by next Friday. By next Friday,
हाँ जी
the learned counsel for the state is directed to seek instructions from the concerned officer in charge of the concerned police station and file an affidavit regarding service of notice. Pose this case on 21st February awaiting service
अप्लाई
in the supplementary process. कंटेम्प्ट पे जब भी नोटिस होगा कंसर्न पुलिस स्टेशन से ही होगा. दे शुड नो पुलिस वाले आके नोटिस सर्व करते हैं तो कंटेम्प्ट कर देंगे.
अपोजिट पार्टी नंबर 2 को आई थिंक मैंने कॉपी भी सर्व नहीं हुआ
नहीं कॉपी सबकी है
स्टेट को क्यों
नहीं
तो बाय नेम पार्टी है ना, तो कैसे ये होगा?
नहीं दे हैव अ रिटेनर काउंसिल
वी डू नॉट नो.
माडा
उनको आना चाहिए.
महावीर प्रसाद अपील कर रहे हैं माडा की
ठीक है, गॉट इट.
So I'm ready this. Item 17 Contempt Bill 546 of 2023.
Yes, petitioner.
My lord, several times this honorable court showed enough mercy and directed to pay, but the opposite party has repeated roughly, my lordship, 4 times they have filed the same affidavit and they deducted by earned leave. My lordship, without any direction they have deducted and passed the reasoned order, and there is no any sign in the reasoned order that the earned leave has deducted and treating absent while the punishment order had been inflicted.
Where is the opposite party?
The physical appearance was also there. In spite of that, from research 2024, the direction was not obeyed. 20/9/2024, 27/9/2024, 6/12/2024.
Mr. Suresh Kumar was appearing in this case throughout. Where is he? उनका नाम फ्लैश करो. नहीं तो एजी साहब को बुलाओ. उनके ऑफिसर लोग नहीं आते तो एजी साहब आएंगे. Yes, who is for the state? You are there for the state? Either you call Mr. Suresh Kumar or you call the learning. Like. बताइए क्या करना है? पेमेंट किए कि नहीं किए?
लॉट
अपील फाइल कर दीजिए. पेमेंट नहीं किया है तो उस ऑर्डर को सेट असाइड करा दीजिए. देयर इज नो प्रॉब्लम अबाउट इट.
सिर्फ
पेमेंट किए कि नहीं किए?
नहीं उसके बाद नहीं
कौन ऑफिसर है किसको हम कंटेम्प्ट में बुक करेंगे? यू चूज द ऑफिसर हु इज रिस्पांसिबल फॉर इट. वील इनिशिएट अ कंटेम्प्ट केस. बाकायदा फॉर्म कौन सा फॉर्म है? आप ये असिस्ट करिए. यू आर नॉट एन ऑफ यू आर नॉट अपियरिंग फॉर द कंटेम्प्ट, राइट?
एक प्रेयर करते हैं
बताइए.
कि इसमें लिखा दिया
हम
APR
हमको क्या लिखाना है ये हम डिसाइड करेंगे.
इट इज माय प्रेयर सबमिशन कि पेमेंट अगर नहीं होता है अगली बार तो सेक्रेटरी अपीयर करेगा और मंडे को रखिए. मंडे तो छुट्टी है, ट्यूसडे वेडनेसडे जिस दिन व्हाटएवर पर सेक्रेटरी को अपीयर करना.
Contempt Civil 546 of 2023. Counsel for the petition is pressed. He submits that in spite of repeated affidavits and repeated orders of this court, the order passed by this court in the petition has not been complied. The learned counsel for the opposite party, Mr. Suresh Kumar,
SC
SC within bracket L and C, that includes Roman 2, has submitted that he has no explanation for non-compliance of the order passed by this court.
एक्सप्लेनेशन तो उन लोगों का तो है लेकिन
No,
नहीं।
non-compliance of order passed by this court, it was also, and the explanation which was furnished through their show cause has already been taken care of
Yes.
while passing order dated 16/12/24. The summary said the matter be posted on Monday and
Monday छुट्टी है।
on Tuesday. Post this case on Tuesday. कौन अपील करेंगे?
I think secretary
बाकी सबका नाम काटा हुआ है.
DFO
Okay. डायरेक्शन किसको हुआ?
DFO जामदार अभी लास्ट एफिडेविट फाइल किए DFO जामदार
नहीं, सेक्रेटरी फॉरेस्ट एंड एनवायरनमेंट डिपार्टमेंट.
yes
The Secretary Forest and Environment Department, Government of Jharkhand, is directed to file a show cause as to why contempt proceedings be not initiated for willful and non-compliance of for willful non-compliance of the order passed by this court. This court is prima facie satisfied that there is
last affidavit we have said everything
this court is,
comparison it may be
yes, this court is prima facie satisfied that the opposite party has no regards for the order passed by this court and has
I think उसको which one
and has willfully complied and has willfully not complied the order. The office is directed to issue notice to the opposite party, to the Secretary Forest and Environment Department, Secretary Forest and Environment Department, Government of Jharkhand, Ranchi.
And climate change.
Sorry,
Forest environment and climate
climate change
Forest, Environment and
and
Climate Change Department. जो आपके cause title में लिखा हुआ हम तो वही लिखेंगे ना. Secretary Forest and Environment Department, Ranchi. यहाँ पे है ना, और having his office at Nepal House,
yes
Yes, my lord.
Doranda, Ranchi. Through special messenger आप जमा कर दीजिए. Special messenger post. आप कर देंगे? पता है कैसे करते हैं?
नहीं.
अच्छा कोई बात. It will be open to the aforesaid authority to engage an independent counsel to represent him before this court. As the state cannot represent a contender before, उनको अपना वकील करना है. अब आपसे नहीं समझ
एक
हो गया. दोनों चीज नहीं चलती.
एक साथ
दोनों चीज नहीं चलता है.
ट्यूजडे इस पर दिया है हम why are
कोई बात
bring why
कोई
are
बात
bring
नहीं.
हम बातचीत किए हैं that's
बातचीत की है ना, कंप्लायंस रिपोर्ट फाइल कर दीजिए.
हाँ, तो कंप्लायंस रिपोर्ट के लिए हम फाइल कर सकते हैं. मान लीजिए अगर इफ दे विल फाइल तो फिर उसका जरूरत नहीं पड़ेगा. दैट्स व्हाई ओनली ट्यूजडे.
At this, the counsel for the state has submitted that there is all likelihood that the secretary may file the compliance report before this
Yes.
court. If the compliance report is filed before this court and the amount is remitted in the account of the petitioner, the appropriate order will be passed on the next date. Okay. Post on 28th of February. The required affidavit should be filed by 24th February.
Thank you, my lord.
regarding item number 9. I am appearing for Jharkhand also.
कोई बात
उसमें
नहीं, नोटिस कर नहीं कॉल करेंगे नेक्स्ट
बस उसको क्या चाहिए नोटिस का वजह जो है कि ये कर दिया जाए
कुछ नहीं करना चलिए नेक्स्ट केस अच्छा अब एक मिनट
Item 18, contempt civil 1127 of 2023.
Malad, now supplementary stock is ready now. Malad, the amount has been sanctioned, my lord, and that has been submitted before the treasury for the payment. It's under process now. I will get 2 to 3 days or 4 days. 4 working days.
I have filed it with vendor, my lord, in this case. And the date they have mentioned in which I was out of service is wrong, my lord. I have filed, my lord, page number 6, and I have annexed that.
तो कुछ नहीं कर सकते हैं अब इनका जो भी है अपना जो भी इनका पेमेंट है आप करेंगे इट इज नॉट अ प्रोसीजर इसलिए रिजॉइंडर में वो रेक्टिफाई नहीं हो सकता कंटेम्प्ट केस सिविल नंबर 1127 of 23 counsel for the parties are present then the counsel for the state Mr. Vijay Chandra submits that the show cause is ready appropriate steps have already been taken to pay the additional amount to the petitioner. He submits that the matter will be posted on next Friday.
Yes, sir.
On next Friday. The affidavit will be filed after remitting the amount in the account of petitioner. Post on next Friday.
Item 19, contempt civil 768 of 2024.
Order having complied with the petition as one as it is man.
Joint contempt civil 768 of 24. Counsel for the parties are present. Counsel for the petitioner submits. Counsel for the parties jointly submit that order passed by this court has been complied, though belated. Order dated 1/7/24 passed in WPS number 7058 of 23. Considering the submissions, this court is not inclined to proceed any further in this continuous proceedings. Next.
Item 20, CIP 946 of 2024.
Yes.
registration. One page was not visible, it was not filed in time, municipal is common audited. And I had eye on it on that day, some kind of extent, but it was.
आइए फाइल करके प्रॉब्लम सॉल्व नहीं होती उसको मेंशन करके लिस्ट भी कराना एनीवेज वेयर इज द ऑर्डर
Order, common order, my lord. There is a no delay, my lord. Only one order was there to comply the order. I have through supplementary order.
वेयर इज द ऑर्डर
With the
इसका नॉन कंप्लायंस
fixed किया हुआ था. Order was not supplied, but it was.
आपने ऑर्डर वाज नॉट सप्लाई ये क्या डिफेक्ट में है
तो लगा दिया.
आखिर ऑर्डर तो हमेशा लगता है ना ऑफिस का कोई विड्रॉ होता है ऑर्डर
Assigned it. Order now, common. Thereafter the. The staff reporter has actually filed a copy of it. I filed the copy of it.
कहाँ है कॉपी ये सीएलपी में तो नहीं है वो तो रीड में है
नहीं सेक्शन में इसमें तो
और बाद में फाइल हुआ और नीचे
हाँ
इसमें भी कहाँ फाइल
उसका गलती से ये प्राइवेट केस में तो फाइल नहीं होता है. नेक्स्ट वीक रख देगा फोटो कॉपी
क्या डिफेक्ट नहीं रिमूव किए थे आप?
किए थे तभी लगा है ऑर्डर से
और ये क्या किस चीज़ में लगा हेडिंग क्या है ये गलती से ही लगा है लेकिन
फाइल कर दिए थे
क्या?
रिटर्न नहीं आ रहा
नहीं भेजे होंगे ना पता ही है आपको ऑफिस तो हम ही लोग की तरह चलता है जैसे हम लोग हैं वैसे ऑफिस वैसे ही एडवोकेट तो एक ही टाइप
बात करते हैं इसलिए अब एडमिशन में लगा तो
कोई बात बताइए नॉन प्रेम्प्टी ऑर्डर में डिफेक्ट नहीं रिमूव किए
हाँ उस दिन नहीं कर पाया था आई वाज फाइन लेकिन नॉट कंसिडरेशन वन
CLP number 946 of 2024. This petition has been filed for restoration of WPS number 6258 of 2023, which was dismissed on 18/6/2024 for non-compliance of order dated 17/5/2024, whereby the defects were not removed. The learned counsel for the petitioner has submitted that a petition was also filed seeking extension of time, but the same could not be taken up, and ultimately the case was dismissed by the court. The counsel for the opposite party has no serious objection to the prayer for restoration. Considering the submissions, time for removal of defect in WPS number 6258 of 2023 is extended till 14th of February. ठीक है? Preemptory रह जाएगा, ध्यान दीजिएगा. If the defects are removed within time, the petition be posted before appropriate bench as per roster. This CLP is accordingly dismissed. Next.
Item number 20, the compliance was made worse. My appearance also with the
Video recording में
I was just running notes.
कोई बात अरे भाई आपके फेवर में ऑर्डर हो गया ना you be happy.
फिर इनका नाम लिखाता हूँ जब जैसे टू कृष्ण मुरारी लिखा जाए तो
हाँ तो जेसी तो कुछ आप दे दीजिए अपीयरेंस आपका नाम नहीं आ सकता
ठीक है जैसे टू कृष्ण
हाँ हाँ वो जैसा अपीयरेंस देंगे वैसा ही आप उनको अपना नाम भी कैरी नहीं करने देना कैसा है आपका ऑर्गेनाइजेशन
बहुत तरह के चक्कर है वहाँ ऑब्जेक्शन कर देता है
आपका बात नहीं मानता आपका क्लाइंट आप भी बताइए ठीक लगता है बोलने में इतना सीनियर हो गया कुछ दिन बाद आपके सीनियर बन गए
ऑब्जेक्शन कर दिया था
आजकल के जूनियर लोग सीनियर के सीनियर हैं सुपर सीनियर
कॉर्पोरेशन है ना प्राइवेट रहता तो कोई दिक्कत नहीं
ऐसा नहीं करिए आप लोग सही बात नहीं उनको जूनियर पैनल में डलवाइए
ना पैनल में है तब है इनका बिल अलग बनता है
Item 21, Contempt 1016 of 2024.
अच्छा वकील है आपके
उनका बंदा है सर
ही इज अ वेरी गुड काउंसलर
दैट आई हैव ओनली इंश्योर्ड
अपना डिटेल दीजिए तो आपको किसी केस में अमाइका सपोर्ट
जी जी
आप ही के खिलाफ
हाँ
बताइए
Compliance of the lawsuit, we have passed the reason order, affidavit has not been
डन
And same as
हाँ है रीजन ऑर्डर
just I have received on mail, madam. Same order was passed on 18/12/24, 18/12 और communicate भी कर दी by post में.
आप देख लीजिए ड्रॉप कर देंगे उनको कॉपी दे दीजिए ठीक है पास ओवर प्रोवाइडिंग अ कॉपी सॉफ्ट कॉपी भी दे दीजिए है ना देन वी विल ड्रॉप द रिस्पॉन्स एंड यू हैव टू प्रोवाइड अ कॉपी टू अस
Yes.
Item 22, CRMP 3451 of 2024.
व्हाट हैपेंड क्यों नहीं कर पाए CRMP we'll just extend the time for removal of defect. ऐसे रेस्टोर नहीं करेंगे जो भी डिफेक्ट है we'll just extend the time. सरेंडर सर्टिफिकेट फाइल करना है तो करना ही पड़ेगा. CRMP number 3451 of 2024. The learned counsel for the parties are present. Counsel for the petitioners. This petition has been filed for restoration of criminal division number 679 of 2023, which stood dismissed on 12/7/2024 due to non-removal of defects in terms of order dated 22/6/2024. Counsel for the petitioner has submitted that on account of on account of certain fault on the part of the advocate clerk, the defect could not be removed as he had gone to his native place to serve his ill mother. Counsel for the opposite party has no serious objection to the opposite party state has no serious objection to the prayer for restoration. Considering the aforesaid submissions, time for removal of defect in criminal revision number 679 of 2023 is extended till 21st February. If the defects are removed, if the defects in the criminal revision is removed within the extended time, office is directed to place the criminal revision before appropriate bench as per roster. As a, you see, the order still continues to be plain. If you do not remove the defect, the matter will again stand for dismissal. We do not. Nothing was filed. You kept the matter pending. We will not grant you any such time. आप अपने उसमें एक्सप्लेनेशन दिए हैं कि एडवोकेट के क्लर्क के चलते नहीं हो पाए। लिटिगेंट क्या कर रहा था? उनको नहीं पता है सरेंडर करना है। उसके लिए क्लर्क की क्या जरूरत है? Yes, there is no explanation for not surrendering. Correct?
Item 24, CRP 7 of 2025.
Yes.
DFD और नंबर इसमें 12 साल को DFD और 22 का ऑर्डर को कंप्लायंस नहीं किया। इसमें ये
कहाँ है ऑर्डर? कन्विक्शन कब का है?
कन्विक्शन है लो। ये सर्विस मैटर है WP से आता है कन्वर्ट हुआ था ये क्रिमिनल डिवीजन।
अच्छा।
एग्रीड को
Where is the order?
लगाए में लो।
कहाँ लगाए?
That is on page 9 लो। जो आपको मिला।
Page 9. डिफेक्ट नहीं रिमूव किए ना आप?
हाँ डिफेक्ट नहीं।
एक्सटेंड कर देंगे आपका डिफेक्ट रिमूव करना।
क्योंकि केवल एग्रीड पोर्शन को आपको ऐड करना है। तो आप
कर लीजिएगा।
अभी कर दीजिए।
ऐसा नहीं होता ना। इतना स्पीड में चलना था तो DFD नहीं करना था।
At that occasion, I was not present in the court.
Criminal CRMP number, you were not present at your own risk, right?
The common order से बोला।
आपको एक चीज बता दे रहे हैं, जरा वीडियो खोल के देख लीजिएगा, एक-एक केस कॉल आउट होता है यहाँ। ऑर्डर कॉमन जरूर ड्रॉप करते हैं क्योंकि हमारे स्टेनोग्राफर को हम अननेसेसरी DFD वाले केसेस का बर्डन नहीं देना चाहते। So don't tell me कि कॉमन ऑर्डर से हुआ।
हम प्रेजेंट नहीं थे।
आप नहीं थे प्रेजेंट तो देखना चाहिए ना। आप ये मत बोलिए कि कॉमन ऑर्डर से हुआ। Every case is independently called out and then we pass the order. हाँ, order इसलिए common draw करते हैं क्योंकि we do not want to burden our stenographer unnecessarily for those cases where the parties are not interested in pursuing the case. ठीक है, इसीलिए हम एक-एक केस call out करते हैं। भले 100 ही केस क्यों नहीं? क्योंकि हो सकता है कोई आदमी को इग्नोर करने के लिए बोले defect. There is possibility, no? We have to give chance to the counsel also. There may be many defects which are required to be ignored, isn't it? Okay. CRMP number 23546 of 24. Counsel for the parties are present. This petition has been filed for restoration of criminal revision number 903 of 2023, which stood dismissed for default on 12/7/2024 by virtue of non-compliance of order dated 22/6/2024. The learned counsel for the appellant has submitted, petitioner has submitted that due to inadvertence and bona fide mistake, the defects could not be removed within time. Counsel for the opposite party has no serious objection to the prayer for restoration. Considering the approached submission, the time for removal of defect in criminal division number 906 of 2023 is extended till 14th of February. If the defects are removed within the extended time, office is directed to place the case before appropriate bench as per register. The records of the criminal division is available before this court. It will be open to the petitioner to remove one or the other defect in the criminal division during the procedure. CRMP
Appearance.
is disposed of.
Item 26 CMP 83 of 2025.
Yes.
Also, in the order for the winner word has been missing also, and the party position also. And it should
Intervention was allowed.
yes, lots of additional one. I know that the 4 of 2024 has been allowed dated 12 November 2024.
Any objection?
No, your ladyship, I am appearing for respondent 789.
Do you have any objection? Do you have any objection? CMP number 185 of 2025. Also for the parties are present. This petition has been filed for modification of order dated 19/11/2024 passed in WPC number 2954 of 2021. The learned counsel for the petition has submitted that the name of intervener is not reflecting in the party position. He has referred to the order dated 12th of November 2024 passed in WPC whereby passed in WPC number 2954 of 2021, wherein the intervention application was allowed, though it was observed that the intervener need not file any complaint. However, this court finds that upon perusal of the records and the order dated 19th of November 2024, the order dated 19th November 24 passing WPC number 2954 of 21 is modified and the name of the intervener newly
Rajiv Prasad and intervener Parmeshwar Prasad Mehta.
Parmeshwar Prasad Mehta, son of late Dukhan Mehto,
Yes.
is directed to be shown as intervener. Office is directed to carry out necessary insertion in the order dated 19th of November 2024. बाकी डिटेल क्या है उनका? असल में जो ऑर्डर हुआ था ना IA में उसमें there was no direction that he should be identified. That is why it is. This court also finds that once an order for intervention, once the intervention was allowed, appropriate order ought to have been passed by this court to include the intervener as a party respondent number 10, right?
Yes.
In the writ petition. Consequently, बस बाकी इतना से हो जाए. Office will do the list. The CMP is accordingly. Counsel for the opposite parties have no serious objection to the pairs and modification.
Item 27 CRP 144 of
इंटरवीनियर का
2025.
बाकी डिटेल दे दीजिए ना, उनका रेजिडेंशियल एड्रेस पूरा लिख के दे दीजिए. ऑलरेडी मेंशन वो इंटरवीनियर का डिटेल जो है ना आईए में मेंशन करके डिस्पोजल हुआ था, नाम, पेरेंटेज और एड्रेस पूरा साथ ही में सुना और ऑर्डर में उसको इन्वर्टेड कॉमा होगा.
Lodging the resulting for today because file has been misplaced.
We will need to work. Yes. Restoration का फाइल misplace कर दिए. This is too much.
Criminal division 45.
कोई बात नहीं, इनका जो है ना
For non-compliance of order dated 2/7/2024.
रेस्टोर कर देते हैं. हाँ. रिवीजन का फाइल तो है ना. You remove the defects in the revision. I'll give you extension of time for removal. Surrender करना है तो करना पड़ता है. इसको याद रखिएगा. देखिए. CRLP number 144 of 2025. This petition has been filed for restoration of criminal revision number 45 of 2024, which stood dismissed for non-compliance of order dated 2/7/2024. ये जरा देखिए तो आईए नंबर 672 ऑफ 24 कब फाइल हुआ. Six 72 of 24.
Meeting 132.
The learned counsel for the petition has submitted that amongst other defects, one of the defects was regarding filing of surrender certificate, for which IA number 672 of 2024 was filed within the specific time, but the same could not be mentioned and placed before this court when the order dated 2/7/2024 was passed. She submits that the division be restored to its original file so that the IA can be pressed and appropriate order be passed. She has also submitted that so far as other defects are concerned, the same will also be removed. Considering counsel for the opposite party has no serious objection to the prayer for restoration, considering the aforesaid submissions, the time for removal of defects in criminal revision number 45 of 2024 is extended till 21st of February. In the meantime, it will be open to the petitioner to mentioned the criminal revision application so that appropriate order be passed on IN number 672 of 2024. If the defects are removed within the extended period, an appropriate order is also passed on IN number 672 of 2024. Office is directed to आप इसको simplicity restore ही करें. Criminal revision number such and such is restored to its original. आप बाकी मेंशन कर दीजिए. This CRMP is accordingly disposed. Office is directed to place the उतना direction का भी हो सकता है.
Item 28 contains civil.
इसमें extension of time नहीं.
Item 28 contains civil 144 of 2025.
Yes.
Is number 20 the relevant portion wherein the respondent number 3 has been directed to needful in accordance with law within a period of 3 months from the date of the representation. But no any needful action has been taken by the respondent.
What was the needful action?
Needful action is the public encroachment on road lordship, and on this ground the petitioner is affected. He is not went in the house by the public.
Yes. Counsel for the parties are present. The learned counsel for the opposite party prays for time to file show cause/compliance report. Considering the nature of the order, the show cause/compliance report should indicate as to what action has been taken by the respondent number 3 pursuant to the representation filed by the petitioner. Post this case on 21st February. The required affidavit of opposite party be filed by 17th of February.
Item 29 contains civil 147 of 2025.
The order of the arising out of WPS number 1998 of 2023 has not been complied by the Opposite Parties Commission. What should have been pleased to allow that writ petition stating and granting 15 days period to the petitioner to file a representation before the Opposite Parties Commission.
You filed it within that time?
Yes, on 20th of February we have filed that representation. Order is dated of 7th of February 2024. With the direction number 2, Your Worship, page number 17. Page number 26, we have received for the date.
This is your signature or whose signature is this?
Worship, this is my signature.
Of DSI in charge special branch.
Yes.
You were the petitioner.
Yes. Rajesh Kumar Singh.
Contempt civil 147 of 2025. आपको क्या करना है?
Time will be given to file so.
Counsel for the state. Compliance file करनी है. Counsel for the state. Prays for time to file to seek instructions and file compliance report. Post on 21st February. The compliance report is filed by 18th of February.
Item 30 CRMP 213 of 2025.
Yes. Modification.
Yes, Your Lordship. Your Lordship, kindly refer to annexure to page number 24. In this, Your Lordship, I am the complainant of a case of 138 NII. Your Lordship, when the accused claims was with an idea for exemption from surrender, there was a condition imposed on him to deposit the entire compensation amount of 1,80,000 to the account of Jharkhand High. Thereafter, Your Lordship, on 11/9/2024, during the disposal of the criminal division, by acknowledging the fact that the amount has been deposited, the order was set aside. Your Lordship, but there was no direction to give that amount to the complainant, Your Lordship. So the modification is required on that respect that the amount deposited by the then accused be released in favor.
No, I don't get it. I'm not able to understand. This revision is pending or disputed?
It has been disposed.
By which order?
By order dated 11/9/2024, which is annexure 3. The relevant part is at Your Lordship, page number 27, the last paragraph. The learned counsel for the parties noted their submission and noted the total compensation amount of rupees has been deposited by the petitioner. The judgment dated so and so, passed by so and so, is set aside. Your Lordship, by considering that the compensation amount has been deposited, the order was set aside. But there is no direction for release of that amount in my favor.
You are the complainant?
Yes, Your Lordship.
Whom are you representing? Whom are you representing? Are you for the state? बताइए क्या बोलना है?
Serious objection.
हाँ?
Objection, serious objection नहीं.
क्या चीज़ का serious objection?
Amount released in favor of complainant.
आप देख रहे हैं डिवीजन में इंक्लूड ऑर्डर सेट असाइड हो गया. किसके फेवर में रिलीज है? In the revision, what has happened? The complainant deposited the amount in this court. The amount was deposited by the accused, right? And ultimately, on the deposit, the revision was allowed. It means what? It means that the order of conviction is set aside.
Yes.
So what is the consequence? The money will go to the accused.
Your Lordship, it has been set aside only on the ground that
We will not modify this order in this manner. You have to go to the Honorable Supreme Court. We can't do anything about it.
Your Lordship, in that manner.
इतना बात तो आपको समझ में आ ही गया होगा by this time. आप silent क्यों?
Your Lordship, that is what I'm saying.
No, that is what I am also saying.
Your Lordship, I got your point. What I'm saying
You
is-
got it much earlier.
No,
Your senior is a very seasoned senior, so don't tell me that you did not get it. Okay? You understand. We do not.
In that case, 1 week's time may be given. I'll examine this particular point and I'll get instructions from that and I'll.
Conviction set aside हो जाएगा तो पैसा accused को जाएगा, complainant को कैसे जाएगा? ये state खड़ा होकर बोले इनको कोई objection नहीं है. आपके घर का पैसा है. बिना नोटिस किए 138 में ऑर्डर हो जाएगा कि कोई ऑब्जेक्शन नहीं है. बताइए, आपको पेमेंट करना है, स्टेट को पेमेंट करना है, ऑब्जेक्शन नहीं है.
ये केस पीपी सरकार है वहाँ है नहीं.
देखिए एक चीज बता दे रहे हैं, यहाँ पे ना प्रॉक्सी में मत एप्लाई हुआ करिए. ऐसे खड़ा ऑर्नामेंटल खड़ा होकर शर्म नहीं लगता है? बोल रहे हैं कि आपको कुछ पता नहीं है. हमको तो शर्म लग रहा है कि हम आपसे पूछ लिए जिसको कुछ पता नहीं. Counsel for the petitioner prays for time to examine as to whether the amount can be released in favor of the complainant once the order of when once the criminal revision challenging the order of conviction has been set aside. Correct? कब तक? Post on 14th? Senior से समझ के आइए. Post on 14th. Interesting आप लोग काम कराते हैं. हाँ? कुछ एरर हो गया है, लेकिन आई एम नॉट द सेम जज टू रेक्टिफाई इट. So something is required to be done.
Also, a case of certificate is that made contempt civil 1159 of 2024.
I'm sorry, that actually I was having some health problems yesterday.
अब ठीक है?
Yes. The order of first receive has been complied or receive. I am having the letter sent to the Treasury also.
AG Jharkhand?
Yes, sir.
उनको दीजिए.
I have already.
स्टेट को दे दिए. ऑर्डर आ गया, आप देख लीजिए इसको. अब देखिए एजी बिहार को एफिडेविट फाइल करने के लिए क्या लिखा? Just examine the review has to be done by the state of Jharkhand.
AG बिहार के लेटर पे ऑथोरिटी स्लिप हम लोग इशू किए हैं.
अच्छा.
AG बिहार ऑलरेडी हम लोगों को ऑथोरिटी स्लिप के तब ट्रेजरी ऑफिसर को हम लोग चेक किए.
ओ तो ट्रेजरी ऑफिसर से अब पेंशन पेमेंट करने का.
हाँ जी जी.
स्टेट कहाँ है यहाँ? ट्रेजरी ऑफिसर के पास ये नहीं जाएंगे, आप पेमेंट इनके अकाउंट में करेंगे. ट्रेजरी ऑफिसर को खुश करने की कोई जरूरत नहीं है, इज जस्ट अ कस्टोडियन ऑफ मनी. बताइए कौन सा अकाउंट में पेमेंट करना है आपको पैसे? दीजिए. यस? नहीं पता?
पता है हम अगर अकाउंट प्रोवाइड हम लोग करा देते हैं हमारा 100 क्लियर होगा. Only this matter will be kept pending for only 7 days to 10 days.
It will be kept pending.
That's all. But in the meantime, I will try to get my instruction from my client.
What instruction?
Instruction because with regard to that details of account number, in which account the account amount has to be credited. See sir.
आपका क्लाइंट फोन पर अवेलेबल नहीं है?
नहीं फोन नहीं होगा. फोन पे होगा.
आप दीजिए ना, आप इसी में लिखेंगे, वो तो उसमें डिपॉजिट करेंगे. पेंशन का सारा डिटेल्स तो होगा आपके पास.
रिप्स को डायरेक्शन से सर्टेन डॉक्यूमेंट भेजने के लिए एजी बिहार.
तो सब हो गया.
जी जी उसी के बेसिस पे एजी बिहार.
Everything is over. Now, in order to get the money, who has to take action? The treasury officer. Only the bank account details are required. Correct?
Yes, sir.
Learned counsel for the opposite parties have submitted that the claim of the petitioner has been processed and the treasury officer has been directed to make payment to the petitioner in PPO number 108456. Correct? ये है ना number? Counsel for the petitioner has submitted that the amount has not yet been credited in the account of the petitioner. The petitioner being an old lady.
Yes. Very old.
He shall seek instructions and give the bank account details of the petitioner, supported by her Aadhaar card and a copy of the bank passbook. Ranchi की रहने वाली है, कराची. Let the required affidavit be filed by the petitioner by next week. By next week, post on 7th of February.
After 10. Because some personal reason. After
Post on 14th of February. ये आपको मिल गया दोनों डॉक्यूमेंट?
नहीं हमको ये 14 फोटोज में कॉपी
दे देंगे आप?
जी हमको
The documents produced by the opposite party is kept on record. The opposite party is directed to furnish a copy of the same to the petitioner as well.
मतलब 14th I was going out of the station 14th
आप तो बोले 10 तारीख तक
जी
नहीं
10 को भी एक फंक्शन है हमारा फैमिली फंक्शन है 14 को भी आई एम गोइंग आउट मतलब ऑलरेडी therefore my next for the subsequent 21st some person I am going out I will not be out of the station
कोई बात नहीं यार नहीं भी रहेंगे तो एफिडेविट तो फाइल करिए ना
जी जी
एफिडेविट फाइल करिए नेक्स्ट फ्राइडे को रख
जी that's my
पोस्ट ऑन नेक्स्ट फ्राइडे
next ठीक
एफिडेविट फाइल हो जाएगा फिर आपकी कोई जरूरत ही नहीं
जी जी अगर हम नहीं मिले किसी मन में भी आप सेंड
एफिडेविट फाइल
जी
नेक्स्ट फ्राइडे को इतना एज हो गया ना
जी 70
उसके लिए एक दिन भी भारी है
जी 70 ओके
Assault case from date is item 21, contempt 1016 of 2024.
Yes. Where is the petition? Order has been complied. उनको दे दिए.
Yes, madam.
ये क्या है?
The order which is the pension and the claim of the petition was rejected.
Has been rejected.
As per the rules, they are not entitled.
Content civil 1016 of 24. Counsel for the parties are present. The counsel for the opposite party has produced a copy of the order passed by
Deputy Commissioner. Oh, sorry, Commissioner. Municipal Commissioner.
by the
Municipal Commissioner.
municipal commissioner, whereby the claim of the petitioner has been rejected. He submits that the order passed by this court has been complied. Counsel for the petitioner submits that right be reserved with the petitioner to take appropriate steps in connection with the reason order. Right? After hearing the counsel for the parties, the order passed by this court in WPS number 1471 of 23, dated 10/4/24, having been complied, this court is not inclined to proceed any further in this contempt proceedings. However, it will be open to the right is reserved with the petitioner to take steps in connection with the reasoned order as may be permissible. Contempt proceedings are brought.
Item 23, DA 10242 of 2024.
Yes.
Leadership, this matter has thrice been rejected. The impute order.
What is the stage of the trial?
It is pending for final argument. The impute
At the
order,
back end of the trial, we will not release you on bail.
at least some time, then
कब से चल रहा है?
I would study since 2018, 22/4/2018. it is.
Part argument was advanced by defense counsel. Fixed for rest of the arguments on 23/12/24. अभी तक conclude नहीं हुआ? Are you sure? Have you taken up-to-date instructions?
Yes, ladies and gentlemen.
Expected time is 1 to 2 months. Yeah, also. For completion, for passing of final judgment. BA number 10242 of 2024. The counsel for the petitioner has submitted that the prayer for bail of the application has been rejected thrice by this court. And the petitioner is in custody since
22/4/2018.
22/4/2018. a report has been received from the concerned court which is dated 20/12/2024 indicating that part argument was advanced by learned defence counsel and the case was fixed for his rest argument on 23/12/2024. It has also been mentioned in the report that expected time for disposal of the case may be 1 to 2 months. Considering the report of the learned court, at this, the counsel for the petitioner has submitted that some observation may be made so that the final judgment is ultimately passed. Counsel for the state has submitted that the trial is at fag end. The matter is at the stage of final argument. The petitioner may not be released on bail. Considering the aforesaid submissions, the argument in the trial has already commenced. But this court is not inclined to enlarge the petitioner on bail. However, it is sufficient to observe that the learned court shall make all endeavour to dispose of the case as early as possible. The parties took, without giving unnecessary attendance, the parties took next.
Ladyship, as per report also, it says that the report is dated 23/12 because a month has lapsed. Because a time may kindly be given a month.
कितना दे सकते थे?
Only argument has been left in this case.
आप करिए ना argument, day to day argument करिए. कौन मना किया?
टाइम का टाइम में तो टाइम पीरियड फिक्स
हो सकता है अभी तक डिस्पोजल हो गया होगा.
नहीं, देखो टाइम पीरियड तो फिक्स कर दिया जाता है 1 महीना जो भी होता है.
आपके कहने से ऑर्डर नहीं होता. सुप्रीम कोर्ट का ऑर्डर देखिए. सुप्रीम कोर्ट मना करता है इस तरह का कोई भी टाइम फ्रेम नहीं फिक्स करना.
तो इसमें भी पूरा विटनेस एग्जामिन हो गया है.
अभी हियरिंग चल रहा है ना आपका?
नहीं, हियरिंग नहीं चल रहा है. 21 में पूरा विटनेस एग्जामिन हो गया. केवल आर्गुमेंट है.
आर्गुमेंट में आपका डिफेंस काउंसिल आर्गुमेंट कमेंस करके आधा आर्गुमेंट कर चुके हैं. कुछ आपको अप टू डेट खबर ही नहीं रहता है. आपका डिफेंस पहले प्रोसिक्यूशन बहस किया होगा ना, फिर डिफेंस बहस किया होगा क्रिमिनल केस में. डिफेंस का आर्गुमेंट भी आधा हो चुका है. आप जाके डे टू डे बहस करिए. कौन मना किया? ठीक है, रिपोर्ट नहीं देख रहे हैं, रिकॉर्ड नहीं देख रहे हैं.
पहले भी एक बार आर्गुमेंट हो गया तो प्रिजाइडिंग ऑफिसर चेंज हो गया. इसके चलते
फिर से शुरू हो गया. चिंता नहीं करिए, हो जाएगा. खाली आप रोज बहस करने के लिए तैयार.
From supplementary list, got to be mentioned item 1, WPS 2429 of 2010.
अच्छा, ओके. क्या डेट क्या चेंज करना था? ओके ओके. WPL number is तो list हुआ है. WPL number 2429 of 2010. The matter has been listed at the instance of the office. It has been pointed out that the case number has been wrongly typed in the final judgment dated 28/1/2025. Considering the submissions, the case number in final judgment dated 28/1/2025 is directed to be read as WPL number 2429 of 2010 instead of WPC number 2429 of 2010. Office is directed to carry out necessary corrections in the order dated 28/1/2025.
For first filing item 3, WPS 3092 of 2022.
this case, you know, all the petitions belongs to BBK Industry also, Vinod Bihari Coil Engine. We have Industry Department. AK Mehta Imperial.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the respondents have filed a counter affidavit stating that the case is covered by the judgment passed in LPA number 658 of 2018, decided on 28/9/2020. We have submitted that similar matters bearing WPS number 1850 of 2021 with WPS number 3093 of 2022 have been referred to have been directed to be placed before the Honorable Chief Justice in his administrative site for appropriate order. इसका जरा स्टेटस बताइए तो 1850 of 21.
हम भी देख रहे थे आ नहीं रहा है सर जब तक असाइन हुआ है
चेक करिए 1850 of 2020. ऐसा है हम ऑर्डर कर देते हैं लेकिन अगर मान लीजिए उसका फाइल मंगा के देख लेंगे अगर मान लीजिए कोई ऑर्डर उसमें हो चुका होगा तो फिर हम अकॉर्डिंगली ऑर्डर अभी तो हम एज्यूम कर रहे हैं कि इट इज आउट ऑफ स्टोरी जैसा
हाँ ठीक है फिर ऐसे नहीं होगा तो फिर यहाँ बस
हम अपना देख लेंगे ऑर्डर दिखाई सर ऑर्डर चीफ साहब यहाँ प्लेस करने वाला कोई ऑर्डर नहीं The learned counsel has submitted that identical matter is involved in the present case. However, he is not aware as to what is the present status of WPS number 1850 of 2021, which as per a computer is showing out of list. इनको इसको भी भेज देते हैं ऑर्डर की कॉपी आपको पता है देंगे ना counsel for the respondents has also no serious objection for passing appropriate order in this case also as has been passed in WPS number 1850 on 10th of July 2020. Considering the aforesaid submissions, let this matter be placed before the Honorable Chief Justice in his administrative side for appropriate order, along with the order passed in WPS number 1850 of 2020.
कब हो जाएगा उसी में तो ऑर्डर में चीफ जस्टिस वाज नॉट देयर अब मेरे ख्याल से
अब हो सकता है नजर में नहीं
नजर में नहीं आया हो जी
इतना थोड़ी याद रहता है
नहीं,
कौन सा केस में क्या ऑर्डर किए
नहीं हम वो बोल भी नहीं रहे हम ऑर्डर लेके इसलिए आए
ठीक तो इतना मेंशनिंग में इतना दिमाग मत लगाइए आराम से आपका टर्न का
नहीं मेरा
फाइल देख के ऑर्डर
उस समय लास्ट वीक मेरा फॉल्ट था इसलिए हम आए थे
कोई बात नहीं डिसमिस तो नहीं किया ना
नहीं कभी भी नहीं आप एक अपॉर्चुनिटी दिए
परमिशन
यहाँ पे हम लोग डीएफडी करने के लिए नहीं बैठे डिसाइड करने के लिए जब ऐसा फीलिंग होता है कि काउंसिल इज नॉट इंटरेस्टेड और मे बी द लिटिगेंट इज नॉट इंटरेस्टेड तभी डीएफडी करना
Partition items is WPC 3265 of 2023.
Yes, you are there. You have filed your affidavit. So, what is your stand? You have annexed a copy of the circulars?
Also, we have annexed the copy of the order through which Your Lordship the compensation amount was stated.
You have stated that the determination of compensation is done through the provisions of National Highway Act 1956. On the last day, they had submitted that the same principles are applicable. That was a wrong submission.
With the rejoinder, Lordship, the notices which they have annexed, Lordship, that has been given to them under 37(2) of the 2013 Act, Lordship. Lordship has sought instruction on that, Lordship, but that was an inadvertent error on the.
Where do you say so?
So I had an oral.
ऐसा oral submission नहीं होता है कि आपने किसी provision को invoke करके notice दिया है आपको clarify करना ही होगा
Lordship.
तो क्या करते हैं आप?
Copy was served on 28th of Lordship. The files were sought instruction, Lordship, but we could not find the affidavit to that on the rejoinder.
तो उसी का ना ये लोग point उठा रहे हैं
Lordship, however, it can be differentiated to Lordship that in the counter filed by the state, Your Lordship, on 20.
Have they stated that road notice has been wrongly issued?
Lordship, it has not been stated, but Lordship,
हम कहाँ से ये लिख देंगे road notice has been wrongly issued?
Lordship, however, the accusation which has happened, Your Lordship, in
Maybe,
the notification of
but
that is
if you
annexed in the counter.
once you mention that the notice has been issued under such and such provision of law, then under such circumstances they are bound to take advantage unless you put it on affidavit that the notice was wrongly mentioning the provision of law.
For that, Lordship, I pray for some time, Lordship, bring that affidavit on.
देखिए मामला बहुत सीरियस है
Lordship,
चीज़ों को थोड़ा सीरियसली
Lordship, therefore,
लीजिए
Lordship, I could not file the affidavit, Lordship, in time, but I sought oral instruction.
The learned counsel for the parties are present. The learned counsel for the petitioner, the learned counsel for the state has submitted that, has filed an affidavit of the district land acquisition officer during the court proceedings, which is taken on record. The learned counsel submits that in paragraph 6 of this affidavit, it has been mentioned that the determination of compensation is done through the statutory provisions under National Highway Act 1956. He has further submitted that you have received instructions.
Oral instruction.
You have received oral instruction. Should I record it?
Lordship, it may be. Lordship, I pray then sometime, Lordship, will bring it on affidavit.
The learned counsel has further submitted that the reference of Land Acquisition Act 2013 in the various notices which has been issued to the claimant pursuant to the acquisition was essentially on account of inadvertence. However, no such affidavit has been placed on record. इसको clarify देखिए दो चीज हो सकता है. Either the principles are applicable and therefore you have mentioned it. If simpliciter principles are applicable for the purposes of assessment of compensation, then we will not adjudicate as to whether this act by itself is applicable or not, because that is a beneficial provision for the purposes of computation and nothing more, right? Then you will be governed by, then this case will not be decided on that, because they say that this act is not applicable. That is computation, the method of computation is applicable, is a different one.
Other land of other villages were also acquired to lordship through the same person lordship. So it is
If somebody does not challenge, that doesn't legalize your
action.
action.
Lordship, the money had come and some of the residents of the village area have
आप
also
लोग
taken the
पेमेंट लिए
compensation.
है कि नहीं लिया?
नहीं, कुछ लिए हैं।
Some have.
तो जिन लोगों ने पेमेंट ले लिया है वो पहले जमा कर दें।
कुछ लिए
जो लिए हैं वो तो जमा करेंगे ना, क्योंकि आपके अनुसार तो एक्विजिशन लिखे हैं, अंडरटेकिंग आपका एफिडेविट में फाइल कर दीजिए, एफिडेविट में फाइल कर दीजिए दैट यू आर रेडी टू डिपॉजिट द एंटायर कॉम्पनसेशन अमाउंट रिसीव्ड, तभी ना होगा. If the accusation is null and void, then whatever amount you have received, you can't have it both ways.
Then we be a store.
Yes, yes, of course.
Must to
Of course.
store your.
You have already been dispossessed.
Yes, ma'am.
Have you already been dispossessed?
Inner position.
Sorry?
In original position.
You have already been dispossessed. ठीक है, वो तो आपको
रोड बना
release
दी,
मिलेगा.
रोड बना दी.
अब फाइल कर दीजिए. अगर मान लीजिए इनका मतलब this accusation is under National Highway Act 1956, then your writ does not survive.
Yes, the Council of State has not stated the National Act has been
They have stated.
also not notified
Sorry?
under the principle of Constitution of India by the government.
That is not the relief which has been sought for. The relief is only in
But
connection with
They
2013
have
Act.
not given to any application your land has been acquired under the.
They have
NIA.
annexed
They have not
They have
given to the
annexed the
land
notification.
owner.
They have annexed the notification.
Notification but not given to the.
That was published in the newspaper.
Public paper में publish होता है, एक एक आदमी को थोड़ी जाके दिया जाता है.
विलेज मीटिंग करना है तो विलेज मीटिंग भी करना है विलेज मीटिंग भी नहीं की है.
वो अलग बात है.
अब ऐसा
The
कानून
procedure not being followed is separate thing. Your relief is that this act is not applicable in
not
Shivamogga.
applicable, not notified. It is by.
If that act,
Right.
इतना एजिटेटेड होने की बात नहीं है. अगर 2013 एक्ट में एक्यूजिशन हुआ ही नहीं है, तो वो इस केस में कैसे डिसाइड होगा कि वो एक्ट एप्लीकेबल है? बस इतना सा बात आपको हमको सेटिस्फाई करना होगा. Then you will have no cause of action.
Governor to say I have notified.
Yes, it is there.
Not say. They
Yes.
have given कि not application given, that's why they not true.
सुनिए हिंदी में बोलिए, आपका अंग्रेजी हमको समझ में नहीं.
कह रहे हैं गवर्नर कहे हैं कि हमने अब रिप्रेजेंटेशन नहीं दी है, एप्लीकेशन नहीं दी है, इसलिए मैंने नोटिफाई नहीं किया.
ऑनरेबल गवर्नर साहब का बात छोड़िए, नोटिफिकेशन रिकॉर्ड पर है कि नहीं? उसमें आपका जमीन है कि नहीं?
गवर्नर इज सो.
आपका नोटिफिकेशन रिकॉर्ड पर है कि नहीं? एक्विजिशन का नोटिफिकेशन रिकॉर्ड पर है? यस और नो? है. वो किस प्रोविजन में है?
क्या किए हैं?
क्या किए आप?
हम लोग
आप
गांव वाले रहते हैं, गांव वाले कहाँ मालूम है?
वो लोग तो इलिटरेट है गांव वाले.
अनएजुकेटेड.
एडवोकेट भी अनएजुकेटेड है क्या? हम तो आपको विद्वान अधिवक्ता बुलाते हैं.
हमने
विद्वान अधिवक्ता साहब जरा नोटिफिकेशन पढ़ के बताइए.
That's why I am speaking about it.
आप नोटिफिकेशन पढ़ के बताइए कि किस प्रोविजन में एक्विजिशन हुआ है.
In IATB is also not notified by the governor and the.
That is not the subject matter.
Subject matter is also.
That is not the subject matter of the.
The governor will say कि I have notified that. नहीं.
वो तो आ ही गया है स्टेट.
नहीं आया है कि notify हम किए हैं under the principle of Constitution of India. This legislative power delegate.
आप हमको इतना बात बताइए कि 1956 एक्ट का कोई भी एक्विजिशन से रिलेटेड इस रिट पिटीशन में आपका डिस्प्यूट नहीं है. आपका डिस्प्यूट सिर्फ 2013 एक्ट से रिलेटेड.
जब मेरे पास पेपर था तब तक मालूम था, नहीं लिखा है. जितना नहीं था पेपर किसे लिखते कि नहीं
नोटिफिकेशन आपके पास नहीं था, ये तो नहीं मान सकते ना.
नहीं सर्विस भी नहीं की है, किसे पता है?
सर्विस
जो किए हुआ है उसके तहत ये रीट लिखा है.
सर्विस नहीं होता नोटिफिकेशन का. नोटिफिकेशन इज अ पब्लिक डॉक्यूमेंट. इट इज
सर्विस तो की, नोटिस तो सर्विस की है.
तभी ना आपको
हम आए नहीं तब नहीं आया.
आप जब गए होंगे तो पता चला होगा ना कि आपका जमीन इस नोटिफिकेशन में कवर्ड है, या वो भी नहीं देखा.
कवर्ड है तो क्या हम तो नोट जो पेपर में हमको दिए उसका ऐसे
ठीक है, आप फाइल करिए.
वर्नर में क्लिफाई.
आपको सीपीसी का बेसिक प्रिंसिपल पता है ना. पिटिशनर हैज टू मेक आउट अ केस.
I make out
You will see whether you have made out a case or not. That is a separate thing. It is a petitioner who has to make out a case.
I make out
the notification.
I invented also.
The rejoinder से case make out नहीं होता है. Rejoinder is a response to the
the part of the deed petition.
अब आपको मेरी बात नहीं समझ आ रही है, ऑर्डर से समझ में आ रही है. फाइनली डिसाइड ही करें, चिंता मत. ठीक है. Let the supplementary counter affidavit of the state be filed by 21st. 3 weeks हो गया. Exactly 3 weeks. Post on 28th. ध्यान से एफिडेविट फाइल करिएगा. कुछ भी एकदम बहुत सोच समझकर उसमें अपना लीगल दिमाग लगाकर तब फाइल करिए. ठीक है. कौन सा प्रोविजन लगता है, कैसे लगता है, वेदर द कैसे एप्लीकेबल होता है, अच्छे से सोच समझ के फाइल. Sorry?
We have taken out all the debates also of this.
Debate से नहीं चलेगा. You see, my only concern is if this land has been acquired under 1956 Act, the relief is not relating to 1956 Act. So they have no cause of action under 2013 Act. If that be so, the case will be accordingly disposed.
Useful area उसका पूरा विवरण भी दे देंगे कि क्या पोजीशन रहेगी. As per the PESA Act, this is also not covered under the PESA Act.
For hearing under order 41 Rule 11, Item 10, Second Appeal 132 of 2018.
This is an appeal referred by the defendant number 2. There is a concurrent finding. The suit was initially decreed. Thereafter, the defendant number 2 bank referred an appeal. That has also been dismissed. So the defendant number 2, the bank is in second appeal. The substantial question of law that was proposed is at page 10, J and M of the memo of appeal. Whether the learned courts below committed serious illegality by not appreciating that appellant granted loan to the defendant number 1 against security for the two fixed deposit accounts standing in the name of plaintiffs, respondent numbers 2 and 3. That too when it has been specifically admitted by the defendant number 1 that he had given the said loan amount to the plaintiffs to meet out their urgent need of money after availing their say for the welfare, acting as the natural guardian. So the plaintiff minors were represented by their uncle, who represented himself as natural guardian. The mother was aware. The bank was not aware of it. That is the case of the bank. Secondly, the other question was M. At next page, page 11. Whether the learned appellate court miserably failed to give clear finding in the aspect as to whether there was any collusion between the appellant and the defendant number 1. That is the bank defendant number 2 and the appellant number 1, based on the learned rule. So if Lordship sees the impute judgment, Lordship will find, after discussing the evidence, suddenly the court comes to section 11 of the Hindu Minority and Guardianship Act. After commencement of the Hindu Minority and Guardianship Act, de facto guardian cannot dispose of the property of a minor. That is the law. But notwithstanding that, when the uncle himself
Did you
represented,
take the required permission from the district?
the thing is the person who is the uncle who represented before the bank as the natural guardian father, he was misrepresented himself, impersonation. So the bank was not aware of it. Thereafter he took a loan on behalf of the minor. The minor plaintiffs came forward and said, this loan was not in my name. So the decree ought to have gone against the defendant number 1 only. Although in the plain ladyship, there is an allegation that there was collusion. But I have examined the evidence of plaintiff who himself deposed as a witness. There is not a single whisper of collusion on part of the bank. In absence of no evidence, the decree, because the bank granted a loan. Ladyship may kindly see page 20 of the impugned judgment onwards of the lower appellate court. Para
Were
20.
you required to take the required permission from the district judge?
Yes, ladyship, that
Did
would.
you get that?
Because
That you are the guardian?
I'm not the guardian. I'm for the
Uncle,
bank.
uncle.
Uncle was supposed to take.
So you are not supposed to take care of that?
He impersonated that he's the father. That's written on the form. That is the basic thing. The bank was not aware of that he is not the father. The bank was under a mistaken belief due to impersonation by that person. He is the uncle. That he is the father. That is what the loan, a fixed deposit says.
Even for natural guardian, it is required. That permission is required.
Yes, under the Guardianship Wards Act, under section 8
Even
also.
for natural guardian, that is required.
It's, if the loan is taken by the natural guardian for the welfare, then certainly that can be avoided. That
avoided means?
The provision of section 8 subsection 2 says that can be taken with the leave of the court, but if not taken, then it can be avoided.
I don't know. Yes. Guardianship and what?
Ladyship may kindly see first the Hindu Succession Act, section 8.
Just a moment.
Minority and Guardianship Act.
Let us see your written statement. Written statement of the bank.
Written statement of the bank.
Yes. What was your written statement?
I have a copy of the written statement.
So you show it from the impugned judgment itself.
Impugned judgment.
You were defendant number 1?
Defendant number 2, para 6.
Para 6. Read it please.
The original Punjab National Bank defendant number 2 filed the first appeal.
No, para number 6 of the trial
No,
court judgment.
This is the written statement of, yes, para 4 at page 3 of the impugned judgment. Punjab National Bank, Distinguished branch.
Para 6.
Para 4.
Sorry, para 6 of the trial court judgment.
Para 6 of the trial court. The defendant number 1 has alleged that the loan was from the. This is the case of defendant number 1.
Yes. Defendant number 1
Okay.
has alleged that the loan of the defendant number 2 against this.
That he's the uncle.
Okay.
Again, the fixed deposit.
Defendant number 2. You read defendant number 2.
Yeah, defendant number 2, para 7. Defendant number 2, Punjab National Bank has filed a written statement stating therein that there has been no collusion between the bank and the defendant number 1, and the bank granted the loan to the defendant number 1 on the fixed deposit plaintiffs according to the banking rules and proposed procedure. It has been stated that the bank and the defendant number 2 has been advanced against the deposits to the defendant number 1 and for the same consent or permission of any court is not required. The defendant number 2 bank has alleged that it is not the concerned whether the loan amount has been utilized for the benefit of the minor or for the plaintiffs, and has stated that it is the defendant number 1's liability to clear the loan taken against the aforesaid fixed deposit and non-payment of the loan interest. The defendant number 2 is appropriate the maturity value of the fixed deposits towards the loan amount of the defendant number 1, and the plaintiff every right to sue the defendant number 1 who is acting as guardian of the plaintiffs to account for the money of the plaintiffs. It has been alleged that the plaintiff number 2 bank has not acted against the interest of the minor plaintiff. Bank is to realize the loan amount from the deposit, fixed deposit, according to the terms of the loan advanced to the defendant number 1. The defendant number 2 bank has stated that according to the banker's right of lien to recover dues, it is entitled to recover the fixed deposits. The plaintiffs cannot raise.
Where is your case? That is not your case. The second appeal number 132 of 2016. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against judgment and decree passed by learned District Judge Woman 2 at Jamshedpur on 8/12/2015 in money appeal number 1 of 1993 within bracket decree sealed and signed on 21/12/2015, whereby the appeal has been dismissed. The judgment of the trial court was passed by judgment dated 18/1989/4/1989 in money suit number 80/143 capital A of 1985/88 by the learned subordinate Judge Woman 3 Jamshedpur, whereby the suit was decreed on contest and the plaintiffs were entitled to realize an amount of ₹35,000 against the defendants jointly and separately. The learned counsel for the appellant has submitted that the defendant number 1 was the principal lien and the defendant number 2 was the concerned bank. He has submitted that as per the case of the plaintiff, the defendant number 2 had pledged the fixed deposits standing in the name of the plaintiffs who were minor at the relevant point of time.
Defendant number 1.
It was pledged by defendant number 1, the uncle of the plaintiffs, and he availed the loan and also became a defaulter. Did he become a defaulter?
Yes, he was a defaulter also.
And
he misrepresented as natural guardian.
and the entire allegation, and he has submitted that the defendant number 1 had misrepresented himself as natural guardian. The learned counsel submits that the liability has been fixed as joint and several primarily on the ground that the interest which accrued in the fixed deposit was paid against the loan amount. Correct? The learned counsel has referred to the substantial question of law which he has framed at para number J and N, which is quoted as this court has gone through the impugned judgments and finds that the learned tried that the specific case and finds that one of the issues which was framed by the trial court was, are the plaintiffs entitled to realize a sum of rupees 35,000 against the defendants? This court finds that the learned trial court has scrutinized the materials on record and has recorded a clear finding that the bank, defendant number 2, advanced the loan to defendant number 1 without express permission from the natural guardian, mother of the plaintiffs, and without taking any permission from the mother. The learned court also recorded that the loan was extended against the norms of the bank. The learned court recorded that when there is an express provision of the bank that without the natural guardian's consent, express permission, a minor's fixed deposit cannot be pledged. And the defendant number 2, that is the bank, had done it and gave loan to defendant number 1 on the fixed deposit of the plaintiffs without taking permission from their mother, the natural guardian. The learned court recorded that there was collusion between defendant number. The action of the bank was arbitrary and in collusion with defendant number 1 and violative of the rules. The learned court thereafter recorded that the defendant number 1 in collusion with defendant number 2 appropriate the interest of the fixed deposit of the plaintiffs for his personal need and thereby took loan of rupees 15,000 also for his benefit and not for the welfare and benefit of the plaintiffs. And consequently held that both the defendants were jointly liable to compensate the plaintiffs for rupees 35,000. And accordingly defeat the suit. This court finds that the learned appellate court has also scrutinized the materials on record and has recorded concurrent finding and dismissed the appeal. The learned appellate court has recorded finding in paragraph 14 as under. This court finds that both the courts have scrutinized the materials on record and come to concurrent findings. The learned counsel for the appellant and has not been able to show any material calling for any material to substantiate any substantial question of law to be formulated in this case. There being no substantial question of law in this appeal is hereby dismissed.
Leadership section 8 is it goes in favor of your leadership views.
Section 8
The
of
National Guardian shall not
Section 8 of Hindu succession.
Hindu guardianship and Section 8 subsection 2. The National Guardian shall not, without the previous permission of the court, mortgage, charge, transfer, or B says, lease or any part with without the, and thereafter subsection 2 is next subsection says any disposal of immovable property by National Guardian contravention subsection 1 or subsection 2 is voidable at the expense of the minor. So they have filed a suit.
The learned courts have also taken into consideration that no permission was sought for from the court to pledge the fixed deposit. That should be sufficient.
That's
Item 11, second appeal 715 of 2020.
In this case, your lordship, after remand, court says reverse the order of the civil court lordship. So it is for the cancellation of the civil lordship and for the
Who remanded the matter?
lordship.
Who remanded the matter? Where is the order of remand?
The order is setting aside the 31st January 2020 lordship and also for the 30th.
Where is the order of remand?
The remand
Who passed the order of remand? You said that there was an order of remand.
Lordship.
Where is the order of remand?
District court.
Then thereafter, after the remand, fresh judgment was passed.
Lordship. Trial court has also reversed the order lordship.
रिवर्स मतलब क्या? वो तो सेट असाइड कर दिया एपेलेट कोर्ट ने, तभी ना रिमांड हुआ. Yes. Appellate court had set aside, found some fault in the order passed by the learned trial court, and consequently set aside the order of the trial court.
They have
and the
totally reversed the handing of the previous order of the lordship trial court. In this case,
previous order कैसे? जब रिमांड हो गया तो previous order कहाँ exist करता है? Previous order से क्या मतलब है इसका?
the same court of previous order.
I don't get it. ट्रायल सूट बताइए, सूट का नंबर बताइए.
50 of 2006.
सूट नंबर, टाइटल सूट है
Lordship.
50 of 2006. ठीक है. इनिशियल जजमेंट क्या हुआ था? बताइए. What was the? It was decreed or dismissed.
Initial judgment had 12/10/2012.
12/10/2012. It was decreed or dismissed.
This decreed.
Decreed.
Lordship. Then in the appeal lordship.
Yes. What was the number of appeal?
Appeal number is lordship 23 of 2013.
23 of 2013. It was remanded.
Remanded.
The trial court judgment must have been set aside. बिना set aside के तो remand नहीं होता.
Yes.
Set aside and remand. It was an open remand.
Lordship.
Then thereafter the suit was again decided.
Lordship.
More evidence was taken. More evidence must have been taken, right? More evidence was taken, and thereafter the suit was dismissed.
Dismissed. And appellate court has confirmed this.
Yes. So पुराना judgment से क्या लेना? क्या मतलब है उसमें?
It has come on record lordship.
It has got no bearing. Now you tell us what is the substantial question of law. There are two concurrent courts which are held against.
Lordship.
You show me the substantial question.
No, lordship, there is a report of CO lordship was strictly stated that the defendant number 3 lost.
Exhibit.
Exhibit 3 lost. Exhibit. ये annexure 3 lost.
Annexure. सेकेंड अपील में कहाँ से annexure आ जाए? एग्जिबिट नंबर बताइए. एग्जिबिट नहीं हुआ है ना. सेकेंड अपील में annexure लगा दीजिएगा. रीट पिटीशन है. एग्जिबिट नंबर बताइए.
ये कुछ टाइम देती है. मंडे को ये कर देंगे पूरा लिस्ट. एग्जिबिट का लिस्ट और ये विटनेसेस लिस्ट. मंडे को
तो ऑर्डर में लिखा रहता है.
ये ऑर्डर में है. हम एक लिस्ट बना के देते हैं.
कोई लिस्ट का जरूरत नहीं. भाई थोड़ा सा किसी से कंसल्ट करके बहस करिए. सेकंड अपील ऐसे एनेक्शर लगा के नहीं होता बहस.
नहीं.
कौन सा एनेक्शर लगाए हैं आप सेकंड अपील में बताइए तो.
ये 3 लॉस.
एनेक्शर 3. व्हाट इज एनेक्शर 3?
अब ये देख एग्जिबिट.
एनेक्शर 3 पत्रांक 403. ठीक.
The first part is stated. Last line was first part. Sudhana. Last line of the first part.
Last line of the first part. Annexure 3. आज से तकरारी 30 से 35 वर्ष पहले ही हो गई.
हाँ 35 से 40 वर्ष पहले ही हो गई
की मृत्यु. सुधा नापित की मृत्यु
तथा वो नावल है इसीलिए स्थिर.
तो ये सर्कल ऑफिसर डिसाइड करेंगे.
नहीं ये रिपोर्ट आया है आफ्टर द ड्यूरिंग द ये जवाबंदी है.
नावल मर गई. कोई डेथ सर्टिफिकेट है आपके पास? नावल मर गई तो डेथ सर्टिफिकेट होगा ना.
ये लोग सिर्फ देख लेंगे एक बार. जहाँ पे जजमेंट
ये डॉक्यूमेंट आपका एग्जिबिट नहीं हुआ. अगर आप यहाँ पे ऐसे डॉक्यूमेंट प्रोड्यूस करेंगे तो अब हम क्या ही बोल सकते हैं.
ये सही. ये हमारे सीनियर का डाला हुआ है.
सवाल पूछे तो सीनियर पे मत पहुंच जाएगा.
नहीं मंडे को कर दिया था. हम पूरा लिस्ट बना के विचार का एग्जीक्यूट से विचार का विटनेसेस. ये रथ हो जनरल दिस.
आप पेज नंबर 108 में आए. सारा एग्जिबिट का लिस्ट है इसमें. इसमें ये डॉक्यूमेंट नहीं है इसीलिए आप उसको लेक्चर बना देंगे. और सोचे कि एक तो यहाँ पर जो है कुछ भी करके एक ऑर्डर हो जाए. नोटिस हो जाए. फिर क्या? आपका नहीं है तो इसको डिस्कस कर देते हैं. फिर क्या है? कौन सा प्रोसीजर रखना है? सेकंड अपील में इलेक्शन. Yes, and you want to verify it. ये exhibit list ये सामने रखा हो. आपको क्या लगता है? ये कोई बेवकूफ है क्या? ऐसा ही लग रहा है. ऐसा कोई इंप्रेशन आप कहीं से कैरी कर लीजिए. लॉ कम आ सकता है हमको लेकिन रिकॉर्ड पढ़ने में हमसे गलती नहीं होती.
एक चांस दे दिया था मंडे को आपकी पूरा लिस्ट हम दे देंगे. ये एग्जीक्यूट.
ठीक है बताइएगा ऑर्डर से. The learned counsel for the appellant is present. he has referred to Exhibit 3, which is the report of the circle officer dated 23/8/2005. To submit that, it has been mentioned therein that Sudha Napir had expired around 30 to 40 years back without any issue. However, during the course of argument, he has not been able to satisfy this court as to whether this document was exhibited and how this document has been considered by both the courts. He seeks adjournment to get ready in the matter. Post on Wednesday in the supplementary was list.
Item 12, second appeal 217 of 2020.
Appellant? Ms. Anjali.
आई में प्रॉब्लम हो गया था
कल से आज आया है ना ये?
नहीं इसमें आई में इंजेक्शन लगा था इसलिए आई ज़्यादा देर फोकस करने में प्रेशर हो जाता लेकिन
कल ही आते हुए थे?
Some other council was appearing.
कल दूसरे काउंसिल एप्लीज हुई, आज के लिए मैटर पोस्ट हुई। आज आप एप्लीज कहाँ है दूसरे काउंसिल को बुला के लेके?
कल नहीं कहा
कल से आज आया है ना?
लास्ट डेट में नोटिस दूसरे काउंसिल तो मैं आई में क्या हुआ रेटिनल इन्फेक्शन हो गया उस रिपोर्ट भी है
नहीं कोई बात नहीं।
ब्लड
ये कल नहीं था क्या?
कल था 2 वीक्स पहले था 2 वीक्स पहले हाँ ये
आपका क्या नाम है?
गौरव कुमार अजीत कुमार
कब करना है?
2 वीक्स फ्राइडे कर दिया है मेरिट है लॉर्डशिप इस केस में ऑलरेडी जो है पर्सन इसमें जो एग्जीक्यूट के डेट वो फाइंडिंग है कोर्ट का कि पहले ही डेट हो चुके हैं वो एग्जीक्यूटेड डॉक्यूमेंट है डिपेंडेंट का
दोनों चीज नहीं चलता ना, पढ़ भी नहीं सकते और बहस भी कर सकते।
पहले का मतलब ऐसा नहीं मेरिट नहीं है इसलिए ऐसा नहीं
Second appeal number 217 of 2020. Mr. Gaurav Kumar, advocate, appears and submits that on account of his eye surgery, he is unable to properly read the file and prepare himself. He pays for
इंजेक्शन ही लॉर्डशिप सर्जरी
आप कब take?
2 वीक्स फ्राइडे को लग गया
He pays for.
He takes it Friday or Mr.
Friday.
Sani has to argue.
He prays for 2 weeks time. Post this case on 18th of February in the supplementary clause list. बाकी कोर्ट में नहीं आती है रूल
नहीं कंटिन्यू ज्यादा देर तक फोकस करने से हो रहा है उतना तक देख पा रहे हैं
15 दिन
इंजेक्शन सर्जरी नहीं हुआ इंजेक्शन लगा आई
इंजेक्शन इन द आई get well soon. ऐसा कोई काम मत करिए, ज्यादा टाइम चाहिए तो और ज्यादा टाइम लीजिए। ऐसा कोई काम मत करिए जिससे आपके आँख में हानि हो जाए। अगर आपको ज्यादा टाइम चाहिए तो और ज्यादा टाइम लीजिए।
4 वीक्स के लिए
Post on 27
yes
in the supplementary process.
Item 13, second appeal 146 of 2023.
May it please the Lord. As against the judgment of affirmance, we are before this honorable court, not in secretary. Now the first substantial question of law for the Lord, it's a money suit. And rupees 66,000 that was taken, I gave him Lord to the defendant. And the defendant Lord executed one hath chitta, small sheet of paper, in which it was averred कि हम and there was a relation. My sister used to live, Lord, in the same village in which the defendant was, Lord, residing, and I was going there, Lord. So therefore, the relationship developed with the defendant, and he started calling me Mama. Now the Hath Chitti that was executed, Mama word has. Now the learned courts below, first I bring to your Lordship's notice that the appellate court did not apply its mind and copied almost the whole judgment of the trial. It's a copy. और उसको हम लोग एक चार्ट बना के भी दिए हैं पैरा so. So this is my first substantial question of law for your Lordship's consideration. That I was deprived of the first consideration and application of mind by the first appellate court, as is required by the.
Where is that question of law?
Pardon?
Where is that question of law?
I have framed.
Where is it?
Mind. My petition memo of appeal, Lord, page 3. Grounds starts, Lord. पूरा चार्ट बना के हम लोग
The discussion of the appellate court starts from para number 24.
Para?
24.
No.
Prior to that, it is just referring to the various documents.
No. Para
24. And
para 30 is the finding.
Para 30 is the finding, but para 24 से discussion start होगा.
हाँ, लेकिन उसके पहले भी फाइंडिंग आया है एपलेट कोर्ट का पैरा 21(2) फाइंडिंग आया है और वो कॉपीड है, वो हम पेज नंबर से दिखा रहे हैं. पैरा 21(2) at page 48 of the appellate court में kindly see. Page 48, Lord, 21(2). I just read, Lord, if exhibit 1 is considered, now this is verbatim copy of para 10.3 of the trial court. Now I'm just placing it on this. Ten 3 of the trial court at page number 72. Page 72 trial court. Para 10.3 मान. Lordship got it. 10.3 of the trial court note at page 72 and 21.2 of appellate court.
Page 72 of the trial court judgment.
Not 72.
Internal page 17.
Page 72 में लॉर्ड 10
Internal page 17. 10.3 तो नहीं है page 72. Internal page
20. Internal page 20.
आप ना अपना जो भी ब्रीफ है उसको इंटरनल पेज से बुला लीजिए क्योंकि आपका मैच
मिनट इंटरनल पेज 20 मिनट 10.3 further if exhibit 1 is considered as a money receipt. Now hubahu the copy has been done now in the appellate court. Finding that exhibit 1 that has चिट्ठी is
आप हमको बताइए ना यही तो एक डॉक्यूमेंट है जिसके ऊपर आप रिलाई कर रहे हैं ये लिखा हुआ है ना इसमें मैं संतोष कुमार भगत
जी
मामा का पैसा समय पर देंगे इतना पाएंगे
my lords.
तो ये इससे क्या ही प्रूव होता है
It is admitted.
This is the only document on the basis of which your case
only
is
document, Lord.
Yes.
Only document.
Yes.
But the finding of the trial court, my lord, is that it is doubtful, tampered. Now this is wholly perverse in view of the fact that this document has been admitted. Execution of this document has been admitted.
Now
Lord.
let us see. Is there any finding? ये जो मामा बोल रहे हैं, तो ये कौन ही है मामा? From where do we get?
Murders.
Show us that
No,
the identity. You see, in a case of promissory note, there is a person who is executing it, and there is a in whose favor it is executed. Now, this particular document, which is the basis of your entire claim, from this document you can infer that this mama is nobody but was the defendant.
Lord, the defendant, the case of the defendant, my lord, in written statement as well as evidence is, my lord, that he has executed in favor of his own mama called Nityanand Bhagat, who is DW3 in this case. He says, defendant, my lord, says that he executed, but mama doesn't refer to the plaintiff.
Yes.
He says that mama, his own mama Nityanand Bhagat. Yes. Now who was examined, my lord, in this case? Now this document who was examined in this case, my lord, and in para 25 Nityanand said, my lord, he did not support this. He said कि हमने कोई कागज उस तरह का देखा ही नहीं जो चिट्ठा के रूप में या promissory note की तरह promise करते हुए place that.
Yes, on the face of this document, it cannot be said that it is executed in favor of the plaintiff.
Lord,
It is not executed in favor
Not-
of the plaintiff. On the face of this document, क्या ही आपका इस second appeal में क्या substantial question of document? On the
Substantial-
face of this document, it is
we always learn from this only.
मामा को पैसा देंगे,
नहीं,
कौन
तो-
मामा,
हाँ तो
किसका मामा, कुछ नहीं।
हुजूर जिस मामा के हुजूर he has been Lord, we have been duped by this. I mean the relationship was so good, Lord. It is a serious matter, Lord. Lord, the finding
you are an alien to the family.
Pardon?
You are an alien to the family.
Whose family?
To the family of the dependent.
No.
You are related to the family of the dependent.
Not related, but I used to go to my sister and he used to come there, Lord.
Admit किए हैं क्या?
हाँ, वो आते जाते रहते थे.
अरे भाई आपको मामा मुंह बोला मामा मानते थे या क्या मानते थे? क्या ही
उनका कहना है कि हम लोग मामा करके नहीं बोलते थे.
बस काफी
लेकिन एलियन अपने को नहीं बता रहा है कि कोई हम लोग माने जान पहचान नहीं थी या मिलना जुलना नहीं था.
प्लेंटिफ का केस बताइए ना क्या है? ऐसे नहीं होता substantial question of law. On the face of this document which has been interpreted.
Not the finding of the court below that the Hath Chitta Exhibit 1 is doubtful and tampered below. इसमें 8,000 का हम पर कॉस्ट भी लगा दिया मैंने. 8,000 का हमारे ऊपर because the courts below not said not found that I have unnecessarily and in on false plea dragged the defendant for 4.5 years for litigation. उस पर 8,000 का हम पर कॉस्ट भी लग गया. Kindly see, Lord, here is a document which is admitted, Lord, by the और जिस मामा के लिए डिफेंडेंट कह रहा है नित्यानंद भगत, he is DW3 and he says, Lord, कि हमने कभी इस डॉक्यूमेंट को देखा ही नहीं और न मेरे लिए ये एग्जीक्यूट हुआ. तो जब मेरे लिए एग्जीक्यूट नहीं हुआ, Lord, how can it, I mean the finding भी कि वो डाउटफुल है, so far I am concerned, Lord. Lord, Nityanand Bhagat's evidence, the Mama's evidence, para 25, 26.
मामा ने ये बोला है कि ये पैसा जो है इनको दिया गया था.
मामा
वो
तो
बोले भाई हमको नहीं पता.
नहीं मामा तो कहते हैं कि हमने पैसा 66,000 हमने ही दिया था, लेकिन ये चिट्ठा उठा वो हमने कभी देखा नहीं.
ये बोला है ना कि हमने ही दिया था 66,000.
हाँ, ये तो बोला है.
तो वो तो प्लेंटिफ है ही नहीं.
हैं?
वो तो प्लेंटिफ नहीं.
वो प्लेंटिफ नहीं है.
तो 66,000 रुपए मामा ने दिया था, ये तो मामा ने एडमिट कर लिया.
लेकिन जो भगना है उस डिफेंडेंट, वो कह रहा है कि हथ चिट्ठा हम एग्जीक्यूट किए थे अपने मामा के नाम, एंड मामा सेज कि हमने कभी वो हथ चिट्ठा देखा ही नहीं. एंड देन हथ चिट्ठा, नॉट काइंडली सी, डिफेंडेंट अगर आई मीन इज अ प्रूव्ड लायर, because the Hath Chitta was in my custody, it is I am producing it as exhibit. That Hath Chitta was not in the hands of Mama or even the defendant, my lord. So the claim of defendant कि हमने मामा के लिए लिख दिया था, तो मामा को लिख दिया था तो मामा को तो हाथ में देगा ना. So therefore there it is falsified, and therefore the finding that in spite of admission, not doubtful, that is a perverse finding.
आपका केस में कुछ नहीं होने वाला. आपका ये जो promissory note जिसको आप बोल रहे हैं, that is not a promissory note in the eyes of law executed in favor of the
हुजूर, लेकिन admission तो है.
admission क्या ही admission? कोई admission नहीं.
हुजूर, the finding that it is doubtful or tampered, how can that?
Essay number 146 of 2022.
And then the appellate court, my lord,
as the court time is over, pose this case for further hearing on Tuesday को further सुनेंगे.
Minus.
कोई time fix कर दें to be taken up at first case
कर
at
दें.
2:15, ठीक है? 2:15 नहीं रखें.
My notes.
ठीक है, 2:15 के लिए
कर देंगे. We stand in light. My notes.
Case.
चार तारीख है सर.
Tuesday मतलब 4 तारीख.
सप्लीमेंट्री सप्ली लिस्ट का नहीं बोलिए ना सर.
हाँ सर, उसमें लिस्ट नहीं बनेगा.
4 पन्ने
एक केस में सबने के निकाल लिया है केस का. हम लगाते रहे.
ट्यूसडे को नहीं बनेगा इसलिए कि मंडे छुट्टी है, इसलिए